Yeah, but don't. Like you can. And it's
Right. So, first of all, as soon as the projector comes up, all right, so we have our attendance pin for today. So we're going to take a minute so that everybody has a chance to get it and enter it. Because I'm not going to be mad if you come up to me after class and are like, oh, I missed the pen, you can give it to me, but like, let's avoid that if we can. So, all right. As promised, we're going to start today with just a lightning round review of Thursday's material, where I'm going to give you the answer, and then if you have any questions, we're going to make sure that we cover those. All right, so starting with number 29, right? This is about whether the Constitution mandates something like the Erie Doctrine. And the argument that Guaranteed Trust offers is that states are sovereign, right? Within a federal system, we have this dual sovereignty system in the United States. And to the extent that the Constitution does not give power or control to the federal government, that state sovereignty remains uninvaded. And so where the states have made policy choices about how to govern claims under their jurisdiction, then federal courts should respect those policy judgments, okay? So as the Guaranteed Trust Court says, we have held that in diversity cases, the federal courts must follow the law of the state as to burden of proof, as to conflict of laws, as to contributory negligence. Erie has been applied with an eye alert to essentials in avoiding disregard of state law in diversity cases in the federal courts. A policy so important to our federalism must be kept free from entanglements with analytical or terminological niceties. Okay. What questions do you guys have about this? No? Good. Okay. So the next question was, what is the actual test that comes out of Guaranteed Trust? And let's see if we can put it this way, okay? When a federal court is adjudicating a state law claim, you apply state law if the application of federal law will create a different outcome than if a state court were adjudicating the same claim. And as you know from what you have already prepared, both for Thursday and for today, this gets more complicated, but this is what comes out of Guaranteed Trust, okay? Is if the outcome changes, if you use federal law, then you use state law, okay? Questions? No? Good.
Question.
Yeah.
The outcome, does the outcome just any different outcome, or how do you like the outcome of the?
So Guaranteed Trust does not say.
Okay.
And as you can tell, as you sort of read on into Byrd and into Hannah, the answer to that is not all outcomes, right? But as far as Guaranteed Trust is concerned, the answer is all outcomes, right? if there's a difference between federal law and state law and who wins, then you apply state law. Okay. All right. Other questions? No? Okay. So, next question. This is one of those trick questions. Okay. So, before guarantee trust, we had this notion in, sort of growing out of Justice Reed's concurrence in Erie that you applied federal procedural law and state substantive law. And in reading guarantee trust, you may conclude that, well, actually, we sort of wipe that away, right? That guarantee trust is saying, if the outcome is different, then you do a different thing. Then you follow state law. But in reality, the procedural substantive test and the outcome determinative test, they operate in parallel. Okay. So even if a given particular state law would change the outcome if applied in the case, if the court decides that that state law is procedural, they won't apply it. Okay. And so the essence of what we're doing here is recognizing that the federal court, in adjudicating a state law claim, is dealing with a right to recover derived not from the United States, but from one of the states. And because of federalism, the federal court should be mindful and careful about not altering the right which another sovereign has created and for which the federal court is merely an alternative forum. Questions? Yes.
So if we were to see this like on an exam, for example, would we apply both rules or would it really matter?
So your exam taking strategy, at least in this class, should be to apply the law of the class, which means that you should apply, unless you are specifically told, use the doctrine from a particular case or given a date. That means that certain cases are not on the table, right? For example, in the question that we had a few days ago from, that said, this matter was filed in 1843, and that was intended to signal that you should be using the SWIFT regime, right? Unless you are given some sort of signal like that, you should apply the law of the class, which means that the entire body of law that we have studied is the appropriate mechanism. And so to the extent that guarantee trust has been refined or narrowed or overruled by subsequent tests like Byrd or Hanna, you should use that refined or narrowed test. If I tell you, apply guarantee trust to this fact pattern, then you should apply guarantee trust. Okay? So, other questions? Okay? So, now moving on to Byrd. First question is, what happens if we apply federal law in Byrd? The answer is, federal law provides that the appropriate fact finder for the claim is a jury, or the contested issue in the claim is a jury. Okay. And next, sort of moving on from that, right? Because that's sort of straightforward. If you apply state law, South Carolina state law provides that judges act as the fact finder for the contested issue in this claim. The contested issue just to remind you guys, is whether the plaintiff is an employee. Because if they are, then the tort claim goes out the window. They're directed to seek relief through workers' comp. Okay. So now we understand the stakes, right? That we are asking who decides in this case. And the next question, applying guaranteed trust, is this difference, right, between federal and state law, is it outcome determinative? And the Supreme Court certainly seems to think so, right? So they say, here's the relevant language, it may well be that in this personal injury case, the outcome would be substantially affected by whether the issue of immunity is decided by a judge or a jury. Therefore, were outcome the only consideration, a strong case might appear for saying that the federal court should follow the state practice. And boy, doesn't that sound like they're gearing up to overrule guaranteed trust. So what happens after that, right? You're getting asked, what's the source of the federal law in Byrd? And the answer is that this is a Seventh Amendment issue. The Seventh Amendment provides for a right to a jury trial. I'm going to be very honest with you. When I took civil procedure, my first year of law school, because we didn't have a Civ Pro II, my professor explicitly said, we are not going to deal with the Seventh Amendment right to a jury trial because none of it makes any sense. And so I regret to inform you that in this class, we are required to talk about the Seventh Amendment right to a jury trial. We'll give it about as much time as we can, but it's not a priority. So we have this Seventh Amendment right. Whether it exists or not in a given case, that's sort of the hard part. So that is resolved here. Okay, we stipulate that it does apply, that the right to a jury, that the constitutional right to a jury trial applies. And so there is a strong federal policy against allowing state rules to disrupt the judge-jury relationship in the federal courts. And the function assigned to the jury is an essential factor in the process for which the federal Constitution provides. So Byrd is saying that the source of the federal law that is outcome determinative in this case is in fact the Constitution. Okay. Questions about this? Nothing? We're all good? Okay. So what is the source of the state law in question? And it sure sounds like, reading Byrd, that the source of the state law, you know, the fact that the judge is the decision maker on this issue, it's just sort of an exercise of judicial power. Right? It's just sort of a seizure of the right to decide by South Carolina judges. It's an issue of common law. There's no statute that assigns this decision to the judge, and it seems to sort of have developed organically. Like it's just, well, judges just started deciding this, and then they started citing each other for the proposition that they get to decide it, and so it developed into a doctrine. So there is some language in the Byrd opinion that if you're sort of reading how they talk about the South Carolina judges, I think it's easy to fall into the trap of thinking that common law is sort of derogated. That's the verb form of derogatory, if you didn't catch that. So it's derogated in the sense that the court seems to be going, oh, those South Carolina judges, they're doing whatever they want. Like, we gotta put a stop to that. That's not really what's going on, okay? Because Erie's clear. All sources of state law are sort of on an equal footing in terms of whether federal courts should follow them or not, okay? Ultimately, the issue here, the thing that leads the court to conclude that the right to a jury trial trumps the state law that is contrary, is that state laws cannot alter the essential characteristic and function of a federal court. Okay. So what that means is that because this jury right is constitutionalized, and because the Constitution stands above and preempts contrary state law, right? Reaching back to our old buddy, Article 4, Section 2, then that federal law should be followed even in the face of a contrary state law. Okay? Questions? Yes.
Did that overrule their state law for their state courts then, or did it just maintain that test, that rule for the federal courts there?
So that's a Seventh Amendment question.
Okay.
So,
It's okay.
I don't have a great answer for you, at least not today. I could speculate for you. Wait, where's this? Okay, that's not something I need to worry about. Okay, my speculation is that probably not, because the Seventh Amendment grants a right to a jury trial in federal court. And so the right to a jury trial in state court is defined by state constitutions. Okay. Mr. Simmons, did you have a question? Okay. All right. So any other questions? Okay. So we're getting into so this is sort of this is a little taste of the federalism lecture from when I teach Introduction to American Politics in a political science department. So federalism wants a dynamic equilibrium between the federal government and the states. Right? You can think about it, you can think about it like a cake. Some folks conceive of federalism as being kind of like a layer cake. So you got a chocolate layer and a vanilla layer and a strawberry layer. I don't know why you have a Neapolitan cake, but you know, whatever, you do you, boo. And so, each of these layers is a level of government, and they don't overlap. That conception of federalism, pretty out of date. What we do now when we talk about federalism is we talk about it like a marble cake. What is a marble cake? Anybody know? Yeah, Ms. Caballeros.
It's like where you have the vanilla and the chocolate, it's like an active,
Yeah,
they're together.
yeah. If any of you guys like watch baking shows, I don't know, maybe you do. Look, don't judge me. But what you see is you'll see like bakers prepare two different doughs, and then they sort of knead them together, right? And then when they bake, you know, that whole pile of dough, what happens is you have these swirls of the different flavors of cake. Okay. And in a modern federal system, that's more like what happens, where instead of there being specific levels where each type of government operates, there's specific functions that each level of government does at any level. And they're all sort of mixed together and working together to create one delicious political whole. If you believe that, I have a lovely bridge to sell you. Small, non-consecutive bills only, please. I will give you a quick claim deed. But the key piece here, right, is that one of the things that students struggle with is figuring out a sensible rule for the boundaries between federal law and state law. Okay. And part of the reason that we sort of work through the evolution of the doctrine and we read like Swift, that is absolutely not good law anymore, and Guarantee Trust, which has been drastically narrowed and refined over the course of the decades. The reason we read these cases is to help you grasp the boundaries between the state and federal governments. So even though the tests announced in these cases are no longer sort of standing alone good law, we still want you to read them because they help you to piece together the boundaries. Okay? So Byrd announces that constitutional protections overcome the federalism command to use state law to decide state law claims. So where they conflict, a federal law that comes from the Constitution overrides a conflicting state law. Okay? Questions? Good. Yes, Ms. Kemper.
Does it have more to do with the fact that it's a more of a procedural component to it instead of like an outcome, or does it go with them?
Well, I guess my answer to that is, can we think of a constitutional provision that grants a substantive right that would affect a state law claim? I'm sorry?
Then it would be arising under your question though, right? If you're in federal court and have a client.
I think that's probably right. So I think that because of the nature of sort of the scope limitations on the doctrine, that any case where the Byrd issue comes into play is going to involve some sort of procedural due process right, not like a substantive due process or an equal protection right. So, I think that's a great question, and like part of the reason why it took me so is I'm like, well, what would happen? And so I sort of had to think through it. So I really appreciate that. Okay, so now let's get offensive. Mr. Van Diest, could I ask you to join me here at the podium for a moment? There is method to my madness, I promise. So here we have a gentleman with, like me, a need for corrective lenses, like me, a beard, like me, a little bit of a belly, and like me, put it on. So, and like me, a keeper. So I can just sit down, right? Mr. Van Diest can replace me, right? Great. I'm going to sit down. Mr. Van Diest is going to take over teaching, and I'm going to examine you based on what I think you should have learned over the course of the semester. Seem fair? Maybe not. Okay, you can sit down. So when we think about this, right? If you think of me as the state court, Mr. Van Diest as the federal court, and thank you very much for your good humor in this. So if you think about it like this, then I think that what the court is getting at in Byrd begins to become clear. Okay. There are certain things that are essential to a particular institution or a particular person. And those components, those essential characteristics, cannot be changed without fundamentally changing what you are dealing with. And so, for example, for whatever it's worth, the faculty here seem to think I'm an expert in civil procedure. Sure, close enough. And Mr. Van Diest, for all of his virtues, isn't one yet. So he can't just step up and replace me without something being lost. Right? If one of you were to replace me as the instructor in this class, there would not be consistent outcomes for all of you. And so, as the court says it in Guarantee Trust, right? Diversity jurisdiction is founded on assurance to non-resident litigants of courts free from susceptibility to potential local bias. The framers of the Constitution, according to Marshall, entertained apprehensions lest distant suitors be subjected to local bias in state courts, or at least viewed with indulgence the possible fears and apprehensions of such suitors. And so Congress afforded out-of-state litigants another tribunal, not another body of law. The operation of a double system of conflicting laws in the same state is plainly hostile to the reign of law. Certainly the fortuitous circumstance of residence out of the state of one of the parties to a litigation ought not to give rise to a discrimination against others equally concerned, but locally resident. Okay. So, bottom line, TLDR. When a federal court is adjudicating a state law claim, the federal court should imitate the state court to the extent that certain essential characteristics of the federal court system do not prevent the federal court from acting exactly like the state court. Okay. Questions? I say let's get offensive because actually Professor Bahadur's suggested the way he teaches this lesson is he actually has a student get up and imitate his accent. So we're just not doing that. We're not doing that. But questions about this? So aren't you glad I didn't ask you to do that?
You were the state court in that scenario?
Yes,
And he was having to act like you.
right,
Which is, okay. To the point, and
right. Yes,
because he should, because.
let him finish it. Go ahead.
Right.
I'm sorry.
And he should do that to the point of not changing too much.
Except for the essential characteristics, right? Yeah,
Which makes him in.
right. Mr. Wood?
That's gonna say, because if he has the answer sheet, he has the answers to the question.
Well, what I will tell you guys is that I'm not limited by what's in this binder. So certainly it's helpful, right? It reduces my prep time significantly, but you should not be under any illusions that if you steal this out of my office, you are going to be equipped to make an A in this class. So, all right. Other questions? Also, if you steal it out of my office, it's not gonna go well. So it's gonna be cops. It's bad. So, all right. Other questions? Okay. All right. So, Ms. Silva, sorry, we're done with Thursday's material. So, Ms. Silva, I would appreciate it if you could, while I drop things left, right, and center, if you could offer us a test for determining which law to apply based on the cases that we have read so far.
Okay. Okay, so I kind of split it up, but like it all goes kind of together, like, you know, kind of flowy. Anyway, Erie, state substantive law, federal procedural law, but if the outcome will change, if you use federal law, you must use state law. But if the state law will affect a fundamental characteristic of the federal court, then you use the federal law.
Exactly right. I have nothing to add. So, all right. So, moving on, we're going to now talk about the Hannah case. So, Mr. Roberts, what are the conditions precedent for an Erie choice of law issue?
No.
And let me be clear, right? I'm asking the first question on the screen, not the
Gotcha.
second yet.
Gotcha.
So we'll get to the second in a minute.
I actually broke them up this time. First, an action must be filed in federal court with diversity jurisdiction over state law claim, and there must be a conflict between federal and state law.
Exactly right. Okay, so moving on, right? Ms. Feldkamp, given the two conditions that that Mr. Roberts just shared with us, right? How are those conditions met in the facts in Hannah?
I'm sorry, what were the two conditions I heard him, but
Mr. Roberts, let's take it one at a time.
Okay, so there has to be federal diversity claim.
Okay,
And-
so and how is that met in Hannah?
there was a federal.
Exactly right, right? So sometimes it's easier than it sounds. Mr. Roberts, with the second condition?
And then there has to be a conflict between state and federal law.
All right, and what's the conflict in Hannah?
So it was whether there was, it satisfied the federal rules, but it didn't satisfy the state statute, I believe.
For what?
Whether they were served.
Right. Okay, absolutely right. So we have an issue of service. Okay. In the federal rules, Rule 4 gives you the modern Rule 4. I actually haven't gone and looked at the 1965 Rule 4, but the modern Rule 4 gives you this long laundry list of all these different ways that you can serve a defendant and acquire personal jurisdiction over them, or have the court acquire personal jurisdiction over them. And I would not be surprised if in the next couple of decades, we began to see a system where we began to see the development of like service of process via electronic means. We already have, if I remember correctly, I think we have service of process by fax. I could be wrong about that. And I'm not going to waste time looking it up. But that certainly seems to me to be where things are going, that we will begin to see service by electronic means. And as per usual, right, innovations of this sort will start in the federal rules and then diffuse into the states. Okay. So the issue in this case is that the federal rules allow for what's called residence service, where you go to the defendant's house and you leave it there, you leave the papers there with someone of appropriate age. Okay. The idea is if you leave it with their spouse or their roommate or their brother or their parent, or, you know, if we're dealing with like, you know, Overland Park, their housekeeper, you know, things like that, then it'll get to them, right? It's the same as if you'd handed it to them. If you give it to like a child, the child will go, I don't know what this is. And they'll like take it off and they'll draw on it because it's paper, or they'll throw it away or whatever. And that might not be effective service. But if you leave it with an adult at the residence, you can feel confident that the defendant will see it. Massachusetts is not that confident. Massachusetts says you have to actually hand it to the defendant themselves. Okay. So the plaintiff in Hannah complies with Rule 41. The defendant says, wait a minute, this rule is outcome determinative, because by not complying with the Massachusetts rule, you have not affected timely service, which means the claim is due to be dismissed. And therefore, you have to follow the state law. Okay? So this is the sort of issue here. All right? So You're all looking down. Nobody wants to make eye contact. Um, So, Mr. Adams, can you tell us why it is that the defendant wins in the district court?
Because they do rule that it would be a substantive difference between applying the federal and state laws.
Okay, and so how does this Reagan case come into play here?
So I'm pretty sure that was the Kansas case that they talked about, but I didn't entirely understand how it applied, if I'm honest.
Okay,
I'm not sure.
well,
He thinks it was decided wrongly and that. No, I'm not sure. Come on.
well, okay, so what was the rule in question in the Reagan case?
It was,
So one of the things that I will point out is like, when the question says you need to examine another case, probably what that means, and certainly this is what it meant for me, is that the case that we're actually discussing, being Hannah, does not give you enough information to understand what role Reagan plays here. And so you're going to need to go and look up the Reagan case. Okay, so I say that not out of any judgment. I say that as a, hey, here's a useful tip for how to handle things going forward. Okay, so Ms. Caballeros, did you have your hand raised? Do you? No? Okay, fair enough.
Yeah.
Right. So, Mr. Gonzalez, do you have any insight on the Reagan case for us?
No, I
Okay, Mr. Henninger?
Yeah, so the Reagan case, there was a Kansas statute of limitations that said an action started when service was made to the defendant. But under the federal rules, I think it's 3, it says it starts when filing the complaint. So we had that conflict, and the Reagan case came out and said that you could follow the Kansas statute.
Okay, why?
Because
Yes, Ms. McHenry.
Is it because the federal rule would have had no effect on the primary state private entity?
I don't know, is it?
That's what I wrote, so yeah.
Okay, so I phrase my response that way because I want to encourage you guys to have confidence in your own answers, right? When you if you find yourself arguing this issue in front of a judge and you say, well, Your Honor, do I win because of this? The judge is going to go, I don't know, do you? So, so if you think that answer's right, you can say that it's right. You don't have to go, well, is this right? And I don't mean to pick on Ms. McHenry by saying this. This is something that a lot of you have done. So, all right. I think that's, I don't think that's a terrible reading of Reagan. I'm not convinced it's the reading that the trial court used in Hannah. Okay, so Ms. Mussiter, do you have any insight into the reasoning of the trial court in Hannah as to how it applied Reagan?
Other than what's been said, basically the state's interest essentially outweighed the federal interest.
Yeah, basically, the trial court reads Reagan and, sort of the guarantee trust and Byrd and whatnot is saying that when you have a conflict between state law and the federal rules of civil procedure, that state law wins. Okay. So, sorry. So now let's move up a level. why is it that the Court of Appeals affirms the trial court? Mr. Heiston, do you have any thoughts on this?
It seemed like the appellate court upheld the trial court's ruling because it just followed along with that reasoning that we just kind of went with, that state law, when in conflict with federal law, is going to be binding upon that federal court.
I mean, I don't think there's anything wrong with what you've said. I think that there's a missing link in the reasoning. So let's see if we can draw that out. So what is the characteristic of state law here that leads the Court of Appeals to conclude that it should bind the federal court?
I don't know that I have the answer.
Let's work back, right?
Okay.
Think back to the answer that we had here from Ms. Silva, right? What's the first step in determining whether a state law applies?
Whether the law would create different outcomes.
Right? Erie. We're going back to Erie. So what's the first step?
Apply state law where they differ.
Okay. And in what context?
Substantive law.
Right. Okay. So if the state law is substantive, then you apply state law. And what happens is the First Circuit sort of ends the inquiry there. Okay. The First Circuit treats these as nested questions. If the state law is substantive, you apply state law. If the state law is procedural and it conflicts with the federal law, and the conflict is outcome determinative, then you apply state law. Unless the federal procedural rule is an essential characteristic of the federal system. All right. I say all of this, right? This is the First Circuit's reasoning in Hannah. I say all of this to tell you the Supreme Court wipes it all out. Just sweeps it aside. Okay. So now we're going on to the proceedings at the Supreme Court. All right. So, Mr. Brown, what is it that the defendant offers to the Supreme Court as sort of why they should affirm the First Circuit's decision?
So they essentially argue that Erie was like a check on the federal rules of civil procedure, and they stated that state law should be applied if federal law would change the outcome of the case. And here the service requirements would mean that respondent would win in this case.
Say that again. I got lost in the sauce. And that's on me. So say it again.
They argued essentially that Erie was a check on the federal rules of civil procedure. They said that state law should be applied if the federal law would change the outcome of the case.
Yeah, exactly right. Okay. So let's just sort of unpack that just a little bit more different. What is it about state law that would change the outcome if it applied?
I don't remember the specifics of the state law in this case, but I do believe that it would. There was a slight difference in the service requirements. I don't think it wholly changed the outcome, but that's about all I can articulate as far as that's concerned.
Okay. Ms. Olive, can you help us?
I will have to pass today. So sorry.
You got it. Mr. Simmons?
Wouldn't he automatically won if the state was applied?
Right. Untimely service claim is dismissed. Right. And this was similar to the issue in Reagan in that when does the statute of limitations get told is the issue in Reagan. And under federal law, right, you affix the time of the claim for statute of limitations purposes on the date of filing. Under state law in Reagan, you affix the date of the claim for statute of limitations purposes on the date of service. And so literally what happens, right, in Reagan is the plaintiff files their complaint in federal court. They pass off their process papers to the U.S. Marshal for service. The U.S. Marshal serves in accordance with the federal rules of civil procedure, because that's the system that they know and that they operate under. And the court goes, nope, you're done because your process server used the wrong rules. So, you know, I'm sure the U.S. Marshal's office was delighted by this, you know. On the one hand, they get this Supreme Court decision that basically says they're a bunch of incompetents. On the other hand, they never have to do process service again. So, like, there's trade-offs in everything. In Hannah, right? The state law says, thou shalt serve in person by hand. And it is absolutely conceded that the plaintiff did not do so. Okay. And so claim is due to be dismissed, right? At least that's what the defendant wants to say. Here's how the court sort of summarizes the defendant's argument, right? In this case, a determination that the Massachusetts service requirements obtained will result in immediate victory for respondent. If, on the other hand, it should be held that Rule 4D1 is applicable, the litigation will continue with possible victory for petitioner. Therefore, Erie demands application of the Massachusetts rule. All right. Last thing for today. We know, I just told you this, right? So this isn't going to be a surprise. Supreme Court's going to throw this whole argument out. You say this is nonsense. Okay. So Ms. Morgan, can you tell us how the court reaches that conclusion?
I said they say it's invalid because the outcome determinative test was never meant to automatically apply state law. The outcome would be different under federal law, but it was rather to invoke application of the state law, the policies underlying the Erie.
Okay.
So there is an issue.
I think that's right, but I want to draw your attention to a couple of specific things, right? The first one is that the court makes the point that if we buy into the defendant's argument, that we essentially wipe out the federal rules of civil procedure, right? Anywhere that they conflict with state rules is going to be outcome determinative in a particular case where they conflict. Okay. And so the defendant's argument cannot be consistent with the federal court's power over procedural matters as granted by the Rules Enabling Act. Right. Specifically, right? Where there's a conflict between state law and the federal rules of civil procedure, the court does sort of a judo move from Byrd, right? So when I use this metaphor for a specific reason, right? The specific sort of philosophy behind judo as a martial art is the use and control of your opponent's momentum against you, right? Sort of shifting things in a direction where things that were going badly suddenly become favorable to you. And what the court says here is they say, look, Byrd says that essential characteristics of the federal system, including constitutionalized processes, have to trump state law. However, congressional action also trumps state law. And Congress has specifically acted to create the federal rules of civil procedure, or to empower the courts to create the federal rules of civil procedure. And so these rules, where they conflict, have to trump state law. But they make this very subtle point that I want to flag for you guys as we head out the door, because it's going to become important in the next few days. It is true that there have been cases where this court has held applicable a state rule in the face of an argument that the situation was governed by one of the federal rules. For example, Reagan. But the holding of each such case was not that Erie commanded displacement of a federal rule by an inconsistent state rule, but rather that the scope of the federal rule was not as broad as the losing party urged, and therefore, there being no federal rule which covered the point in dispute, Erie commanded the enforcement of state law. And look, I'm going to be straight with you guys. This is sophistry. This is angels dancing on heads of pins kinds of reasoning. This is, oh God, we have these cases that completely contradict what we want to do in this case. How do we distinguish them? Okay. But for us, the key thing here is the court is saying that the federal rules win where they are in conflict with state law. And so that becomes the key question for these cases is there a conflict? Okay, we'll see you guys on Thursday. Take care. We're back on our normal rhythm. So for Thursday, start your prep with question 45 and do 10 questions from there. So see you guys then. Take care, guys.
I think we're starting to ground.
Yeah.